So I think the topic is quite self-explanatory in that it talks about navigating criminal case closure options and strategies. I think the reason this kind of subject can exist is because, as you all know, criminal trials are extremely slow. It's not as simple as you file an FIR, a charge sheet is filed, and then there is either an acquittal or a conviction. What tends to happen in India is because everyone is aware that criminal trials are slow and that every stage will take years, and a culmination in terms of an acquittal or a conviction can take up to 10 to 15 years in many cases, not in custody cases usually, but in many cases. The law factors in certain exit strategies that exist for people to make sure they don't have to suffer an entire trial for 10 or 15 years when they have a good case. And once you get into the practice of criminal law, you'll realize more and more that criminal law exists in two fields. One field is the actual trial, which I won't get into in today's session, which is where witnesses are coming, witnesses are being examined, and you're making arguments and you're cross-examining them. And after which you will enter into the stage of final arguments and then argue the case. The other is the strategies by which a criminal trial can be closed. And I use close as a very broad term here. You'll understand what I mean by it as we go along with the webinar. To get away from a trial, to make sure you don't have to suffer the long trial for 10 or 15 years, especially in a case where you think you're completely innocent, you've been framed, or the material against you is extremely weak. There's no reason for you to suffer 15 years because of such a weak case that has been made out against you. So the first thing you have to realize is there are multiple kinds of criminal cases, right? There are those cases where you file an FIR with the police, and then the police file a charge sheet, and then there are private complaints that are filed with a court. So it makes sense to deal with these separately. So if you look at section 190 of the CRPC or 210 of the BNSS, and the reason I'm going to keep bringing up the CRPC is if you're a practicing lawyer right now, or even if you join the profession, say after a year or two, you'll realize that while the BNSS applies for all new criminal trials and new criminal cases, old cases will continue to follow the CRPC. So it's important for you to know both legislations. Frankly, even today, most of the work I do is under the CRPC. It's only the new matters that come in that go under the BNSS, and therefore you explore it from that angle. But that's why I'll try to give you the section numbers for both. The benefit is the law is still largely the same, even though we have a new criminal code, etc. In a lot of areas, there is a lot of overlap. In fact, many have said, and I think, in fact, Mr. Desai is one of them who I heard him say in court in one matter, that it would have been a lot better if the legislature had sought to just amend the old CRPC and bring in the new, the changes that could have been brought in. Because as of now, there is a familiarity with the CRPC which goes away. And it takes time for everyone to adjust to the new BNSS. And when I say everyone, I don't just mean lawyers. I mean even judges don't have the sections on the tips of their fingers. Even police officers don't have the sections on the tips of their fingers. And it would have been easier to have a familiar book with some changes rather than having a new book entirely with not as many changes that warranted really starting a new book. But anyway, that's neither here nor there. So we'll move to how does the criminal process start, right? Either you file an FIR or under section 190 of CRPC or 210 of the BNSS, you can file a complaint before the magistrate. Now, criminal cases are broadly divided into two categories: warrant cases and summons case. And the other way in which they're divided is, like I said, whether the police file a charge sheet or a police report, as the CRPC and BNSS call it, or whether a private complaint has been filed by an individual. Let's look at what is a warrant case and a summons case, you may wonder. Any case which is punishable with more than 2 years is a warrant case. And anything which is punishable with up to 2 years is a summons case. So a check bouncing case or defamation, since the punishment is only up to 2 years, is what you call a summons case. And complaint for cheating or even say murder, obviously punishable with more than 2 years, therefore becomes a warrant case. Now, proceeding further, let's look at broadly the exit strategies evolve at 3 levels. I'll start with private complaints filed by individuals. In a private complaint filed by an individual, what usually happens is, let's say I am filing a complaint against Malvika. I go to court, I file a private complaint. Now, under the CRPC, what would happen is the court would first examine me in court, take my statement on oath, take the statement of any witnesses I have, and hear those, record their testimony. Thereafter, the court has a decision to make. Either the court can say, I have enough material to to issue process against the accused, which is really the first stage in a criminal trial under the CRPC, because prima facie, that is on the face of it, an offense is made out. Or I have another option, which is I can issue an order to the police to just file a report with me that, look, the complainant has come over here. Aditya has made so and so statements against Malvika. He's examined so and so witnesses. Why don't you also look into the matter and just give me a report? This is a 202 report under the CRPC. Now, once all of this is done, the magistrate has an option to do two things. Either he can issue process under 204 of the CRPC, which is 227 of the BNSS, or he can close the complaint under 203 of the CRPC or 226 of the BNSS. Now, why this is important in private complaints is, as a matter of legal strategy, let's say the magistrate decides to issue process against you, which is he says, okay, I have considered the evidence of Aditya Mehta as a witness, Aditya Mehta's witnesses, all the documents produced by Aditya Mehta, and I have decided that that Malvika seems to have committed the offense of whatever the offense may be. I am going to issue process against her. Why? Malvika, if she believes she has not committed an offense at this stage, need not necessarily face an entire trial. In fact, you will see throughout your career what Malvika can often do in such cases, if she thinks she's completely innocent, is she can file a revision application before the sessions court, because an order of issuance of process is passed by the magistrate. She will file a revision application, which is under 397 of the CRPC or 438 of the BNSS, before the sessions court, saying, look, Aditya has filed a false complaint against me, even though he has recorded his testimony, in the form of his statement in court, in the form of the witnesses he examined, in the form of all these documents. It's a completely false case. No case is made out against me. I shouldn't have to suffer a trial. Please set aside the order of issuance of process against me. Now, in this manner, if Malvika gets relief from the sessions court, rather than her having to come to court before the magistrate, take bail, face an entire trial where Aditya will get to examine all his witnesses, which may be 7 or 8 witnesses. Then Malvika will cross-examine those witnesses. Then Malvika will have a right to record her statement under 313, and then produce defense evidence. And thereafter, final arguments, a process which can take 10 to 12 years, can instead be resolved in the matter of one revision application being filed before the sessions court. This is very common practice, for example, in 138 matters, or in defamation cases, or even in any other kind of private complaint that is usually filed. Do you understand? The importance of this comes from the fact that people who are innocent should not be made to face a trial. And if they are made to face a trial, sometimes the process itself becomes a punishment. And so, if on the face of it a bogus complaint has been filed against them, they should be able to file a revision application, challenge that order issuing process against them in court, and thereafter, if they have a good case, the sessions court will set aside the order issuing process against them and say that no, the magistrate has made a mistake. No criminal offense was made out here. They shouldn't have to suffer. So we have an interesting question from someone from Altaf. Can one file a discharge application on the grounds of defense or of necessity or a right of private defense? Okay, so let's not get ahead of ourselves, Altaf. I'm sorry. I will get to discharge applications. Right now, we are still in a private complaint filed before a magistrate, where there is, in fact, for some, if you remember, I had said summons cases which are punishable up to 2 years, say in check bouncing cases or defamation cases, there is no right to file a discharge at all in law, which is why today, if I filed a private complaint against Malvika for check bouncing, there is no provision in the CRPC which allows her to file for discharge. And therefore, she has to file a revision application in the sessions court. The question that arises is, if Malvika thinks she has a good case, that she's not committed an offense, but the sessions court has still not held in her favor and has disagreed with her and held no, the magistrate was correct. Prima facie, a case is made out against Malvika, she should face trial. Does that mean that Malvika has no other options before her? No, that's not true. She has a power to file a quashing petition before the High Court. This will be under 482 of the CRPC or 528 of the BNSS, saying that, look, this complaint was filed by Aditya against me. The magistrate wrongly issued process against me. The sessions court also wrongly upheld that terrible order of the magistrate. And this case should be closed against me because no offense is made out whatsoever. So you're understanding the levels at which this case is operated. It starts with a private complaint before a magistrate. The magistrate issues process against Malvika. Now, Malvika goes to the sessions court saying, no, no offense was made out. The magistrate should not have issued process against me. The sessions court disagrees with her, and Malvika gets a second bite at the apple by going to the High Court, where she can ask for quashing of both those orders, saying that no, both of them are wrongly held. I should not be made to face an entire trial. Please set aside the order of process against me. Now, technically, Malvika also has the right to go to the Supreme Court if the High Court disagrees with her. But that's because I won't get too much into that because the Supreme Court can be approached against any order that is passed. In fact, that's what a special appeal is, an SLP is. So there is the Supreme Court option as well. But this is now the overall picture of a private complaint where Aditya has approached the magistrate and filed a private complaint before the magistrate in this and said that please issue process against Malvika, and the magistrate has issued process against Malvika. Now, this is a bit of a trick question. The BNSS differs from the CRPC in respect of private complaints. It provides an additional right to Malvika. Under the CRPC, if I filed a private complaint against Malvika, Malvika had no right to be heard until the trial court issued process against her. But what this led to, what was noticed is by the lawmakers, is that people were filing bogus complaints against one another to create pressure tactics, to put someone on the back foot, etc. And therefore, the BNSS incorporates a provision that says that even before the trial court, that is the magistrate, issues process against someone, he has to send a notice to the proposed accused, who is not yet an accused, and inform them that, look, this is the complaint that has come against you. This is the material that has come against you from the complainant. What do you have to say? Should I make you an accused in a criminal trial or should I let you go? So that is an additional process which has to be complied with in the BNSS. It's there to safeguard the rights of people so that they're not, innocent people aren't made accused in criminal trials in private complaints. All right, now let's switch over to police being involved. Now, let's say you file a police complaint. There are two kinds of offenses, if you remember. One is the summons triable and one is the warrant cases. Warrant cases are those punishable with more than 2 years. Summons cases are those punishable with 2 years or less. Let's say I file a police complaint for cheating against Malvika. Everyone over here will probably be aware that every police complaint, unless the police themselves come to the conclusion that there's no offense made out, results in a charge sheet or a final report. That is a police report which will be filed with the magistrate for Malvika. Let's say the offense over here I'm talking about is cheating. A final report goes to the police, the magistrate from the police, saying, yes, this is the material we uncovered in our investigation. These are the witness statements. These are the documents. Malvika has committed the offense of cheating. The magistrate takes cognizance of this police report and thereafter issues summons or a warrant in the name of Malvika. I said summons or warrant. In a summons case, punishable with 2 years or less, let's say the offense in this case that I had complained of was rash driving, which is punishable with less than 2 years, then Malvika would only receive a summons. In a warrant case, the magistrate has the option. So if it is the offense of cheating, the magistrate can either issue a summons saying Malvika should appear before my court, or a warrant asking that Malvika be brought to her court. Usually, magistrates always issue a summons, even if it is a warrant trial case. Moving on, now is the question that Altaf has becomes relevant. Once you have been named in a police report and the magistrate has issued summons for you to come to court, in criminal law, because a police report by its very nature is usually quite detailed and considers all the material, and the fact that the law gives you this alternate remedy, you don't ordinarily challenge an order summoning you to court based on a police report, like you did with a private complaint, where you challenge the summoning order itself. What you usually do is you appear before court, you take bail or a bond from the court, depending on what the facts warrant, and thereafter you file for discharge. Now, that's where Altaf's question comes from, which is a discharge application essentially comes into the category of saying that, look, this is the entirety of the police report. Under section 239 of the CRPC, which converts to 262 of the BNSS, say that even if you consider the entire police report and consider everything found in it to be true, there is no offense made out against me. There is no prima facie case against me. The case is so inherently improbable that it should be considered groundless and I should be discharged from it. Why is this important? Because if you're not discharged, the court will frame charges against you. That is, for example, in our example, you, Malvika, have committed the offense of cheating because of XYZ facts. And how do you plead? And Malvika will plead either guilty or not guilty. And if she pleads not guilty, then a full-fledged trial will follow, requiring the examination of 7 to 10 witnesses. Then there will be 313. Then there will be the defense witnesses. 10 years of your life gone. So the law recognizes that even though the police has come to the conclusion that an offense is made out, an accused does and should have a right to file for discharge and get removed from the particular case, right? Which is where Altaf says, can one file a discharge application on the grounds of defense, of necessity or private defense, right, of private defense? Now, this is an interesting question, Altaf, because usually when you file for discharge, it's difficult to create a defense. A defense is something which has to be proved. And to prove a defense, you will always need to be in the stage of defense evidence, right? Because the police report will only have material that shows its own case. So for example, let's take an example of right of private defense. Altaf's case is basically, let's take an example of Aditya. I filed a police complaint against Malvika because I said that Malvika stabbed me, right? Now, the question is, if the police take my FIR, they file a charge sheet. The police, in that charge sheet, they have recorded my statement where I say that I was walking down the street and Malvika stabbed me. And they'll have 3-4 witnesses in the area who sort of validate what I'm saying, that yes, we turned around and we saw Malvika was holding a knife and Aditya was stabbed. Now, you want to seek discharge. You can't dispute directly what the witnesses have said. Malvika can't say, no, it's not that I just stabbed Aditya. He tried to strangle me. While he was strangling me, I luckily had a pocket knife with me, a Swiss knife with me that I carry for my personal reasons, and I had to stab him to save myself. And obviously, then I'm exercising the right of private defense, and I should be discharged from this case. But in order to prove that you were exercising the right of private defense, you have to prove certain facts. These facts are not on record right now because all that is on record is Aditya's statement and what is in the police report. And that's what's crucial here, is that at the stage of discharge or at the stage of revision, you cannot have any dispute on facts. The moment there is a dispute on facts, a trial court will always hold that, look, this has to be dealt with by a court of law. By a court of law, I mean through a trial. So witnesses have to be examined. Aditya will step in the box. He will have to testify before the court that I was walking down the street, that Malvika stabbed me out of the blue. Then Malvika will get to cross-examine Aditya, saying, did you strangle her? Was she in duress? Was she forced to take out her Swiss knife and defend herself against your actions? All of this cannot be done at the stage of discharge because Aditya never steps in the witness box. The only material in front of the court at the stage of discharge is the police report. And so that is a crucial line to remember, that when you file for discharge, if you make anything a tribal issue, if you make anything a dispute of facts, it is I'm saying X, she's saying Y, the court will 99.9% hold against you, because the court will say, I don't know who to trust. I can't trust Aditya. I can't trust Malvika, because all of that I can only do after the witness has stepped in the witness box and be cross-examined. Moving forward, now there is, like I said, if in a police report in respect of cheating, which is punishable with 7 years, you have a warrant case, which allows you discharge. But in a private police report in respect of a summons case, like I said, rash driving, which is punishable with less than 2 years, even then, under section 258 of the CRPC and 281 of the BNSS, you can file for discharge. Essentially, the grounds are the same. There's a bit of, like some jargon involved of groundless and stop proceedings, no case, etc. But basically, your argument becomes, if you consider the whole police report, there is no offense made out against me. If there is no offense made out against me, I should not have to face an entire trial. If I should not face an entire trial, it will be an injustice to me. So discharge me prior to it. Now, there are a few other ways in which a criminal case also closes. The first of them is compounding. Compounding is when now everyone knows that the difference between, say, crime and contractual disputes is a crime is considered to be a public wrong. And that's why you have the police that pursue it. And, it's the public prosecutor who argues it at the cost of the state of Maharashtra. But what eventually has happened as time has passed and criminal laws have evolved is some crimes have been recognized to be primarily between two people. For example, in the case where Malvika has cheated Aditya, cheating is a criminal offense. It is a public wrong. But the only one who's really suffered is Aditya. And therefore, if Aditya and Malvika can come to some kind of settlement, which might be in Aditya's own interest, if Malvika cheated me and took, say, 30 lakhs from me without, giving me what she was supposed to give me, I think Lorraine, I don't know if I'm saying your name correctly, but Lorraine has said it. Compounding is an amicable settlement. So Malvika took 30 lakhs from me. She's not given me whatever she had promised to give me. I file a cheating case against her. A charge sheet is filed. If at any point Malvika comes to the conclusion that she doesn't want to fight it out in court, she wants to settle the matter, she's willing to return the 30 lakhs to me or the 20 lakhs to me or some amount that we can amicably agree upon, to use the word Lauren has used, then you can file an application for compounding before the trial court, where essentially you tell the trial court, the parties herein have settled the matter. It doesn't amount to a conviction. If I compound the matter, Malvika doesn't have to plead guilty. In fact, the matter is closed as if Malvika did not commit any offense. There's nothing on her record and the case disappears. Now, compounding operates at two levels. One is offenses that you can just compound as a matter of right. These are slightly more basic offenses. And one is offenses where you can compound, but with the permission of the court. The reason this is important is this. Some offenses are inherently serious. And even though we want to encourage settlement, we want people to move forward, our court system is extremely overburdened. You can't allow it to happen without the scrutiny of the court. For example, let's say I'm a really poor person. Malvika cheats me over 30 lakhs. And now I have literally no money left and I'm desperate for my next meal. So I agree to settle the case and compound it for a measly amount of 2 lakhs. And the court obviously cannot allow this to happen because Malvika it would encourage people to cheat poor people and take advantage of them. And therefore, some serious offenses require the scrutiny of the court before they can be compounded. Now, if you look at section 320 of the CRPC or 359 of the BNSS, it has a list of sections which can be compounded. Offenses that are compoundable in nature would be how I would describe it. But there are some offenses which are not on that list. And the reason for that is they are considered so serious that Parliament, when it framed these criminal statutes, did not think that people should be allowed to settle such offenses. A good example of that, for example, is section 467, which is forgery of a valuable security. Now, let's say I have forged a will. I have pretended to make a will. And obviously that person was alive, he didn't die, but he found out I forged the will and kept it ready. So he files a case against me. Usually this would happen between family members, right? So it would be, let's say my father finds out I'd forged his will and kept it ready so that when he passes, I could deny my sister all the property. So he files a case of forgery of a valuable security, which is, by the way, punishable with life imprisonment against me. A charge sheet is filed. All of that is going on. Now, you can't settle this or compound this because Parliament has deemed that 467 is not a compoundable section. But let's say the matter does get settled. I mean, at the end of the day, he is my father. For whatever reason, we realize let bygones be bygones. We don't want to spend whatever time we have left together fighting with each other. Even then, now the High Court, in its inherent power, allows you to quash non-compoundable offenses. So in these kinds of cases, you have to file a quashing petition before the Bombay High Court. The Bombay High Court will consider your quashing petition and realize that since the matter, even though it is such a crucial and inherent wrong that has taken place, there's no point in continuing with this matter. Why should we make a father pursue a matter against his son? If the father is not interested in pursuing the matter, then he'll never appear as a witness. If he appears as a witness, he may not cooperate with what the prosecutor would expect him to say because that's the statement he recorded with the police. So then the High Court has an inherent power to quash those offenses out of an amicable settlement, even if they don't come within the list of compoundable sections in the CRPC. And finally, to move to the narrowest category, which exists in law, but I think in India has not been used to any extent really, is plea bargaining. Plea bargaining, I mean, I think everyone over here at some point or the other would have, I don't know, watched Suits or some of these other TV shows which exists where plea bargaining is, the Lincoln Lawyer, all of that, where plea bargaining is seemingly, at least, not that I've ever practiced in the US, is an inherent part of the criminal process there. which is that there is a genuine threat at all points, that you will face a conviction. If you face a conviction, you may face a sentence of up to, say, life imprisonment to 7 years or 10 years. So it is in your interest to settle this at amicable terms with the police, come to a reasonable sentence, keeping in mind the facts of your crime, rather than spending time and money. By time, I mean advocates' time, judicial time, court time, all that time, police time, witness time, go through that entire rigmarole, which is torture for everybody, and eventually face the same sentence. You sort of agree to a terms on which you will accept your conviction and face a certain prison sentence. It's not done in India, frankly. I don't know a single case of plea bargaining. I've not come across one in my entire practice. And the reason for that, I think, is our criminal law system and the criminal courts are so overburdened and so crippled that every accused is he's going to be hard pressed to consider that I should just admit to my guilt. He'd rather take his chances in court. He doesn't think that he's likely to face a sentence anytime soon if he's out on bail. And he'd rather battle it out and hope for a positive outcome. And then maybe file an appeal and get bail during the appeal as well. Now, I think Kavita has asked a question, which is, what is a valuable security under 467? And actually, valuable security has been defined in the CRPC. So I'm not going to I'll first read out the definition and then we can get into it. Or it's defined in the IPC, I'm sorry, not in CRPC. I'll just open that instead. Essentially, a valuable security is any document from which rights flow. So I have argued in one case that invoices constitute a valuable security, because using an invoice, you can claim payment from somebody. So the definition of valuable security, at least under the IPC, is valuable security denotes a document which is or purports to be a document whereby any legal right is created, extended, transferred, restricted, or where any person acknowledges that he has any liability. Like I said, it creates a right. So, for example, a contract for a sale of a house is a valuable security, because based on that contractual document, one person will claim title to the house, and therefore it creates rights. And so if I forge Malvika's signature and sell her house to, myself at a very cheap rate, that constitutes 467, which is for forgery for the purposes of dealing with the value. Now, I don't know how clear I've been, and I can only hope that you guys have kept up with me. But essentially, once a criminal complaint is filed, I'll just summarize a little. You challenge the order issuing process against you in a private case. In police cases, you generally file a discharge application. If the discharge application is allowed, by the way, I'm sorry, I forgot to mention, in case your discharge application is rejected, you're not without any remedy. You can file a revision against that order before the sessions court, asking the sessions court that, look, I filed for discharge. I say the police report makes out no criminal case against. At this point, in case the sessions court agrees with you, then it can say, yes, you are correct. The trial court ought to have discharged you, and it can close the case against you. If the sessions court rejects your application for discharge, once again, you can go to the Bombay High Court using its inherent power under 482 or 528, as the case may be, and say that, look, the sessions court and magistrate have wrongly considered the facts. I ought to have been discharged. The point of this session is to show you is that criminal trials take time, and innocent people shouldn't have to face criminal trials. And you'll see this day in and day out in your practice, as in when you start, or if you started, you might see it already, where people, rather than facing an entire trial, would rather challenge an order issuing process and revision. I would rather file a discharge application and challenge the discharge application be rejected. If the trial has started and they've managed to settle the matter amicably, they'd rather file for compounding before the trial court. And if the offenses are serious, which cannot be compounded, they'll file a quashing petition. Of course, if all of this fails, you have to face a trial. There will be final arguments. And of course, you all are well aware of the fact that that will culminate in either an acquittal or a conviction. I think Edric Miranda has said that the Mexican thief at the diamond exhibition in Goregaon took plea bargaining. I don't know about this case. It could be that he did. It's possible. And maybe I think that in the future, if our criminal law systems become more and more robust and become more efficient, then eventually the scope for plea bargaining will increase. Because I think the only motivation any accused has to try plea bargaining is knowing that if he doesn't use plea bargaining, he's going to face the music very soon and for sure. So the moment that starts happening, I think, our courtrooms are expanding, hopefully, faster in the near future. We have Mazgaon Court now, which is a new court building in Bombay. which I think is quite fancy and quite nice. It's much better than the previous ballot estate building that used to be there. So if we get more courtrooms, we get more judges. If someone commits an offense, they're caught by the police, and they know that within 2 years they're going to be facing what's potentially a maximum sentence. They have some motivation to consider plea bargaining, because otherwise they're going to spend a boatload of money on legal defense only to eventually face the sentence anyway. Whereas in plea bargaining, they might get a better sentence as well. But so far, to my knowledge, I've not come across any cases of plea bargaining. And even if they exist, I'm sure they do. I'm not questioning what you're saying. They are few and far between and significantly underutilized, not really serving the purpose they were created. I think that's all. Does anyone have any questions that would be really interesting to handle? Anything you didn't understand because I spoke fast or, quickly jumped sections and provisions, something. I know it was a little dense as a session. It really is.
Yeah, but the knowledge is so important.
I hope so. I trust me, and I say this with what happens and tends to happen in Bombay is actually criminal lawyers. Some trials happen, but you can go 3 weeks, 4 weeks without appearing in a single trial, only handling revisions and quashing and all of that. It's because people are so discharge applications and all of that. Because ultimately, that's the only way people can ensure that they don't face that trial. That trial can be a hellish experience. I mean, I'm part of a trial which has 400 witnesses right now. Obviously, the accused wants to get discharged because by the time 400 witnesses are done, he might even be old and dead, and he'll be suffering all his life with having to deal with this trial. Kavita has a question, which is not really relevant to this topic, but I can try and answer it for sure. So, culpable homicide not amounting to murder is punishable in sessions court. Usually, how the stages would be is you file an FIR. An FIR culminates in a charge sheet. Once the charge sheet is filed, because it's a sessions tribal case, the magistrate will remand the case to the sessions court. And then you will file a discharge application before the sessions court if you think you have a good case. If you don't, then the sessions court will reject your discharge application. Then all the witnesses will be examined there. And after that, you will argue for, well, final arguments will take place saying that you're innocent or you're guilty, depending on what material has come on record as evidence from the witnesses. Thereafter, the court will pass a judgment either acquitting you or convicting you. I hope that answers your question.
Okay. So, what is the role of police in closing a criminal case?
See, the police's job actually ends once you file an FIR. Police's job culminates in what report they file with the police with the court. So either they can file a charge sheet, in which case they have said the offense is made out. Then whether the person is discharged, convicted, acquitted is not the police's job. It's between the court and the public prosecutor. The police will just consist of bringing witnesses to court, and the investigating officer is obviously a witness as well. But the police's job ends with the report that is filed in court. So if the police file a charge sheet, then the police has said offense is made out. If the case has to be settled, it is on the court. If the case has to be discharged, it is on the judge. If the case has to be convicted or acquitted, also it's on the. Whereas the police at the stage of FIR can file the C summary report, where they say it is a civil dispute, or they can all kinds of summary reports really. When sometimes they can say that they couldn't identify the offender or that no offense is made out at all. This was a fake case, that's right. So that is the extent of the role the police has. The police in India is relevant at the investigation stage. Once the police file a report in court, whether it is a summary report or a charge sheet, the role of the police ends.
Okay. One more question. This is very common question actually. What can lawyers do for speedy disposal of a criminal case?
I mean, it's a little sad, but sometimes your client won't want speedy disposal of a criminal case. But that being said, and that being slightly unprofessional of lawyers, and you see it day in, day out, what lawyers can do is just come prepared to court. You can't control when a witness will come. You can't control when the court will have time. You can't control when the prosecutor will have time. What you can control is that, if you need to file I don't think I mentioned this, but the new BNSS sets a time limit for filing a discharge application. It says discharge application has to be filed within 60 days of receiving documents. Now you can just by virtue of filing your discharge application in time and making sure the first date for hearing of the discharge application, once the prosecutor's filed its reply, you tell the court you're ready for arguments. That'll lead to speedy disposal. Don't take adjournments on grounds that you're busy or on grounds that you can't prepare or on grounds that you need more time or instructions from your client. Do all that well in advance. And look, a lot of the failures of the criminal justice system are institutional. There's 60, 70, 80, 90, sometimes 120 cases listed before a magistrate. in Andheri court, for example. Can you imagine? The judge sits for 5 hours in a day. So that's 150 minutes. And he has 120 cases on board. If he takes 1 minute per case, then he is left with 30 minutes. So, and then how many witnesses can he examine in one day? How many matters can he hear arguments in one day? Of course, judges have to adapt. Judges go extremely fast in cases that are getting adjourned, etc., etc. But there's only that much a lawyer can do. There's only that much a single judge can do. It's an institutional failure, and the institutions evolve with time to get better. You need more courtrooms. You need more judges. Only after you have that can we really consider other reasons why things are getting delayed. But that being said, I think lawyers have tremendous scope in delaying a matter or being prompt in a matter. And you'll see it in your practice too. You go prepared to court, if you go prepared to court, you're better than half the lawyers in that courtroom, frankly speaking.
Okay. One more question. Practically, can a complainant withdraw his or her complaint?
Yes. So, slightly technical question. I don't know if the phraseology was used broadly. If a complainant has filed an FIR and the FIR has been registered, the complainant can't withdraw an FIR because then it's part of the public process. You have to file an application in the High Court to quash an FIR by consent. But if you file a private complaint in court directly, at any stage you can withdraw it on the counter.
Okay. The next question, not relevant, but still taking it. What is the difference between a police report and a charge sheet?
Charge sheet is a colloquial term. A police report is the term used in the CRPC. You won't find the word charge sheet in the CRPC or the BNSS. Essentially, a police report is a final report. It can come to a conclusion either that an offense is made out or that an offense is not made out. Colloquially, these are referred to in different ways. Charge sheet means yes, the offense is made out. A C summary report means it's a civil dispute.
Okay.
I think Avinash Pujari. There's a question from Lorraine
Yes.
saying is
Yes.
the last phase of a case. Yes, if you're talking about final arguments, once all the evidence is completed, the last thing that happens in a case is final arguments. The prosecution argues for conviction, the accused argues for acquittal, and then there will be just the state of judgment that remains. Altaf is asked, in a discharge application, what are the factors considered by the magistrate? I think it's fairly straightforward. The magistrate has to see whether an prima facie, that is, on the face of it, an offense is made out or not. It's, he considers everything in the report to see whether an offense is made out. So, for example, if I give Malvika 30 lakhs and she's supposed to give me a car, and she gives me a car, but the car doesn't work, and I file a case of cheating against her, the magistrate will say, okay, fine, the police report says Aditya gave 30 lakhs to Malvika. The police report says that Malvika gave a car. The police report says that the car doesn't work. The only argument Malvika can make here for discharge is that this is not a criminal offense. I gave him a car, the car didn't work, he can claim compensation from me in the form of damages. It's a contractual dispute. So even if you consider all the facts to be true, on the face of it, this is not a crime. This is merely a contractual dispute. To pressure me is filed a criminal. That's an example of, say, a discharge application, which the court has to consider, okay, yes, even considering all the facts to be true as stated by both sides, can I come to the conclusion that no offense is made? Or, for example, if it's a dark, in the video, it's an allegation about somebody who's been beaten up by 4 different people in the dark, but the police file a charge sheet saying yes, and they name 4 accused, but none of the witnesses name me. I can file a discharge application saying, look at the final report, nobody has said I'm even present at the scene.
Okay, Aditya. One question, important case laws, but I think it's a very vast topic. So case laws would be so many, right?
You have case law everywhere, don't worry.
Our students are crazy behind case laws.
Case laws are crutches. A teacher of mine used to always say, you should always know your principles, and you'll always, the nature of the number of high court judgments and high courts we have, and even the fact that the Supreme Court sits in so many benches, is any principle in law, you look hard enough, you'll find a case to support it. The question is how you can justify that particular proposition to the judge. Case law is crutches. Always argue on principle. Case law just gives you weight behind what you have to convince a court of anything. That's all. You'll find case law in life. You can't. A lawyer will not get by knowing all the cases in the world. He'll get by knowing all the principles.
Okay, Aditya. So I think we're done with the queries.
Okay, thank you.
Can we conclude? Yeah.
Helpful.
So thank you so much, Aditya, for such an illuminating session. It was a great learning experience, and we are so happy to have you. Thank you.
Thank you. Happy to be here.